7 mistakes you should avoid to protect your assets. Assets are a resource with economic value that an individual, corporation, or country owns or controls with the expectation that it will provide a future benefit. Assets are anything of value that can be converted into cash. Assets may include buildings, investments, money, equipment, and many more. Unfortunately, many mistakes are often made with assets that may cause alarming panic levels for us now and when we are dead. An asset now could well become the backbone of family conflict and legal battles. Assets are not a headache when one is alive because there may be plans and procedures to follow. But once a death certificate is in your name, that becomes a different story. As we progress as a society, it becomes necessary that individuals and companies protect their assets from creditors' claims through financial decisions like asset protection trusts. These trusts are helpful, but then again, what happens when you die? Once a person moves away from their 40s, they need to start making decisions that will outlive them. Not just any decision, but decisions that protect their assets. We should look at 7 of the common mistakes often made when it comes to protecting assets. Before we talk about that, don't forget to hit the subscribe button and turn on the notifications so you will never miss any of our future videos. Number 1. No protection. The easiest mistake to make is not to protect your assets. Sometimes people, in their strange wisdom, leave the protection of their holdings to fate and chance. Nothing works that way globally, especially with all the legal clause ready to seize up assets. Some people have said that they will have to sell their assets to check into an elderly home, so there is no need. This mindset may be expected, but it is not entirely true. There are many life insurances and Medicare insurances that will handle those parts of your aging process if you start now. And that is what I mean by protection. If you invested in insurances today, your assets are going to be okay. However, one must cover their life, children's education, livelihood, and emergencies like sudden disability and death. This proactiveness leaves your other assets protected in the case of any of these situations. Refusing to consider any asset protection plans when you own assets is a terrible idea. It will leave your estate and other assets up for grabs by the government, your creditors, and creditors of your successors, private companies, and many more. There are chances that you may have some assets that nobody knows about, and since it was listed correctly and protected, you will lose them to random people. The most disturbing thing that could happen is your failure to protect your assets in any way. Number 2. Relying on a will. These days, it is also necessary to constantly update your beneficiaries as and when big things happen in your life. Commonly remembered assets can be duly covered by people in wills, but many more assets are not. There are retirement accounts, annuities, IRAs, and life insurance policies. A choice cannot affect these plans because they are all subject to probe, which could be a long and tedious legal process. Those are passed based on the beneficiary designation selected. Not updating the beneficiary when you get married and not updating a beneficiary after divorce can be moving in the wrong direction. You must constantly review your beneficiary designations when significant life changes happen to make sure they fit your current situation and goals. Here is a scenario. A young man, A, was a successful business owner who had many assets to his name. Because he was single, his younger brother was the beneficiary of everything. Then A got married and moved everything into his wife's name in his will. This move was a good idea since his wife was who he wanted to get all his assets. A, however, failed to update his other assets not backed by wills and trusts. Those still had A's brother's name on them, and after the probe, the assets were handed over to the brother. It does not matter what anyone thinks about your decisions. Whoever is your beneficiary gets whatever you left. You will not be around to protest the decisions. Therefore, it is best to not rely on a will. Wills are for assets that you run directly by you, but other assets that corporations run will not be affected by your decision in a will. Number 3. Relying on family members. The burden of relying on family to do the right thing once you are no more may be too much. The taxes and debtors that will rise from your death could be overwhelming. Some may be willing to go along and take the legal route to get the best decision for your children and wife, but others may not be in the position. It may be that they do not have the money to chase after your money, or they do not have the luxury of time to do so. It is essential to do these things yourself and not rely on family to do it when you are no more. This mistake does not only apply to death, Even old age could be burdensome for some people if you failed to insure your assets. Number 4. Co-ownership. On paper, this is a good idea. So if you put your asset in both your and your child's name, that will be the easiest way to give them full ownership. So now, once you die, being your survivor and half-owner, they automatically take full ownership. The challenge? The government is now going to tax them annually if the assets cost more than $13,000. This tax is the tax on lifelong gifts. You or your child's debtors who could not come for the assets because they were in different names will now come and take over because it is officially in one person's name. All the taxes that you have to pay will also roll over to your child. Co-ownership is a lousy way to protect an asset in the long run. Number 5. No protection for disabled beneficiaries. When a disabled beneficiary receives assets from a deceased person, the state stops providing for them. All the benefits they get from the state is cancelled based on the fact that they have an inheritance. Therefore, it is essential to leave an inheritance in a specially drafted trust to protect them and keep them eligible for public assistance. Without public assistance, all the assets will go into medical bills, and the disabled beneficiary will be back to having nothing soon. Number 6. Bad drafting. I will probably explain this better with an example. So, if the will says to share assets equally between children, and then one of the children is dead, what happens? Does the child of the dead beneficiary benefit, or will you only share among the surviving children? Again, if you say that you want your estate to be shared equally among your descendants and have 3 children and 4 grandchildren from one of the children, your assets will be divided into 7 equal parts. That may not be what you meant, but that is what will happen. Again, you must use the best attorneys to draft wills. It is cheaper to draft it yourself, but the legal language could get your assets in the wrong places. Number 7. Minors without guardianships. No trust fund will hand over vast sums of money to a minor. You will need to provide them with a guardian to handle the assets until then. The other side is that once you fail to do this, the trust fund may appoint someone you may not want to oversee your child's money. In the situation of a guardian arrangement done after your death, it is always handed over to the child when they turn 18. This age is not the best to handle a lot of money. Some restrictions also ask that your child cannot make any other financial decisions, like apply for loans until they are down to $2,000. It is better to go through the strenuous processes of guardianship today than let it be terrible tomorrow. The best option is to appoint a guardianship company to handle the guardianship situation for you. Those companies decide the best age to hand over to you. There are many mistakes we make when protecting our assets. We trust family, we make co-ownerships, we don't consider the disability of our survivors or their minor status, and we might draft it wrong. Asset protection is essential, but it may even fail if you don't plan it carefully. The advice is to contact asset protection companies to help you make the right decisions. Please tell us what plans you consider asset protection and what your experiences are with inadequately protected assets passed down to you. Kindly give this video a thumbs up if you enjoyed it.